Plea bargaining is so frequent in the United States that the United States Supreme Court has recognized it as an expected part of the criminal justice process. We'll talk about plea bargaining right now on the LawWorks.
From West Virginia Public Broadcasting.
Closed captioning for the LawWorks is made possible by a grant from the Monongalia County Bar Association to support legal information and education for all West Virginians. The LawWorks is made possible by major grants from the Office of West Virginia Attorney General Darrell McGraw and from Software Systems Incorporated, a West Virginia company established in 1975 which provides high-end support services, programming, and consulting for county government AS400 mid-range computer systems, as well as PC-based systems, and by a grant from the West Virginia Bar Foundation. The West Virginia Bar Foundation, the philanthropic organization for West Virginia's legal profession and justice system, promoting public knowledge of the law in West Virginia.
Is plea bargaining a necessary evil or a constitutional right? My guests are Attorney George Castell, Kanawha County Chief Public Defender, and Attorney Brian Kornbrath, Chief Federal Public Defender for the Northern District of West Virginia. George, Brian, thank you for being with us.
Thanks for having us.
Plea bargaining, what is it?
Well, if I can, I'd like to object or at least express some reservations about the use of the label plea bargaining in the first place. And the problem is with the term bargain. For example, when people talk about corporations in the law, no one uses the term fine bargaining. When people talk about, lawyers talk about divorce, they don't talk about property bargaining. So there's just something unnecessarily negative about the term bargaining rather than plea bargaining, suggesting that there's something basement level about it. It's plea negotiations that result in plea agreements. More neutral terminology, it's a neutral concept, and something about the term bargain just demeans it in a way that shouldn't. Or reflects the demeaning public approach, which I think is misleading.
But I like bargains. When I go to buy something, I want to get a bargain. I want to pay less for it than somebody may be asking for it. Is that not what you're doing in plea negotiations?
Well, just the term bargain seems to cheapen the concept and cheapen the process. Negotiations is it's a legitimate part of the law. It's an important part of the law. It's a necessary part of the law. Not that it can't be abused, and Brian can probably give you as many or more examples than I can of abuse. But conducted properly, it's the legal system as it should be.
But there is a bit of quid pro quo in the plea negotiation process, is there not?
Oh, very much so. I mean, it's a good faith effort from both sides, prosecution and defense, to try to reach a fair resolution and avoid a jury trial. Because as we all, I think, would agree, the time and expense of pulling in citizens, paneling a jury, presenting evidence, argument, it takes days, if not weeks. So both sides look to plea negotiations to avoid the uncertainty of a trial and try to negotiate, not necessarily bargain like George says, but negotiate either for lesser charges, lesser counts, or an agreed upon sentence so that the defendant knows what he or she can expect when they finally do appear in front of the court.
Well, except for avoiding the expense of a trial, what would be in it for the prosecutor? What can a prosecutor expect to get out of this negotiation other than less work?
Well, again, I think there's the uncertainty. No one knows for sure what a jury is going to do given a certain fact pattern. It could be guilty all counts, it could be not guilty all counts. Very seldom do you have a case that is, call it a slam dunk for either side. So I think even a prosecutor looks at a case and says, there's a fair amount of uncertainty here, it might go either way. Let's see if we can resolve it without that actual jury trial.
Have you ever had a criminal trial where the results came out in a completely unexpected way to you?
I hate to admit it, but as a lawyer, part of your job is to advise a client what the chances are at trial. And I have had cases where I've at least advised the client that it looks like the evidence is so overwhelming that a guilty verdict is almost a foregone conclusion. And I've had several cases where the defendant says, "I don't care," and he was found not guilty all counts. So no one can predict what a jury will do in any particular case.
George, have you ever had a case where the jury did something completely unexpected?
Oh, I've been surprised in both directions. Unexpected things happen in the jury room, and we don't know what they are. We only learn the result, not the process. There are occasions where judges will permit jurors to be interviewed after the trial is over and the term of court is over. And in my office, we've tried to do that, but there usually are not in-depth interviews. They're not, many jurors are reluctant to discuss the deliberations at all, and some who do just give us limited responses. So and maybe misleading responses, trying to tell us what they think we want to hear or mislead us, or either side. So what actually goes on in the jury room during jury deliberations, no one really knows.
And I've had cases where typically as a defense attorney, the surprising thing is an acquittal when you expected your client to be convicted. And in a criminal trial, if the defendant is convicted, the judge typically will poll the jury, that is, ask question of the jury, and the question is this your verdict? And he or she will ask each member of the jury, is this your verdict? And in some cases, I want to ask, are you sure? Is this really what you meant to do? Didn't you listen to the evidence? Because we do the best job we can, but we have opinions about cases too. And you listen to the evidence, you listen to your client, and you think, well, this is a conviction coming down the road, and it's not. And then you go home and you worry about yourself, I think, a little bit. How did you miss that?
Sure.
What is the position of plea bargaining within the criminal justice system? Is this something that is sanctioned? Is it something that's expected? Or is it something that kind of happens in the back room?
Oh, it's an open, at least in the modern era, it's an open and legitimate and expected part of the process, and a necessary part of the process. In many instances, law enforcement officers, at least in the state court system that I'm most familiar with, law enforcement officers, with the encouragement of and sometimes participation of the prosecution, bring either the maximum charge they think can possibly be sustainable or overcharge. And sometimes the plea negotiation process is not to reduce the charges to something less than what actually occurred, but is to narrow it to what actually occurred. For example, in a murder, when a charge is murder, the reality could be, the act could be legally first-degree murder, second-degree murder, voluntary manslaughter, involuntary manslaughter, self-defense, not guilty by reason of insanity, or just plain old not guilty. And in a lot of cases, there's a combination of, there's some aspects of many, if not all of those. The barroom brawl, for example, where the winner of the brawl may not have initiated it, may have been drunk to the point that it's arguable whether he was capable of forming any intent at all. But the loser of the argument struck his head and died. The plea negotiations in a case like that can be really intense, really critical, but often can lead to the correct result. So it's not necessarily somebody getting away with less than what he really did. Sometimes it's a plea to exactly what the person did. It's the correct result. The prosecution recognizes it, the defense recognizes it, the victim's family often recognizes it, the prosecution recognizes it, the judge recognizes it. The public may not, but it's only because we've not done a good job of presenting that to the public.
We're talking about the plea bargaining process. My guests are attorneys George Castell, Kanawha County Chief Public Defender, and attorney Brian Kornbrath, Chief Federal Public Defender for the Northern District of West Virginia. I'm Dan Ringer, and this is The Law Works. Why do prosecutors overcharge?
Well, at the federal level, there's actually policy from Maine Justice which requires that the prosecutors pursue criminal charges that are readily provable. In other words, they have to make a good faith assessment that they're confident that they could obtain a finding of guilt beyond a reasonable doubt from a jury before the case is presented to a grand jury for indictment. Am I saying that happens in every case? No, but that's the policy that federal prosecutors are required to follow on a regular basis and in good faith.
But is that really overcharging if it's readily provable? In some instances, primarily in state courts, what I've seen prosecutors do is charge every offense that could be conceivably provable, not readily provable. And frankly, I haven't seen that too much in federal court in the district in which I practice, which is the same district you're in.
Correct. But there are many federal criminal cases where, for example, in the context of a drug case, there may be a firearm involved. So not only do you have a drug crime, you might have a conspiracy allegation, a firearms count, and all of these under what are called federal sentencing guidelines matter. So if you can negotiate away a firearms count that may carry a mandatory minimum sentence, you've saved the defendant a substantial period of time. And in many cases, the prosecutors might be willing to do that. Will allow a plea to a drug count in exchange for dropping the firearms count. And like I said, that matters.
Why do you think prosecutors, at least in the state system, overcharge if they do?
Oh, it's to give them leverage in plea negotiations and give them, something to work with. Sometimes a person will be charged, only commit one act, but will be charged with several offenses that are just duplications. And the plea offer initially will be drop one count if the defendant pleads to the other count. Well, he only did one thing. It's not, it relieves the it relieves the defendant of the possibility of a double sentence. It's abusive in some instances, particularly if only one count is sustainable in the first place. And prosecutors in the state court system are only ethically permitted to pursue charges if they have, the legal term is probable cause to believe that the crime has been committed or that particular offense has been committed. But there's a tendency to overcharge just to have leverage in negotiations. And if it's abused, it's a problem. If it's not abused, it's not.
Does a prosecutor have to pursue every possible charge?
Prosecutor doesn't have to pursue any charge. Prosecutors have total discretion, as do police officers, in whether to bring a charge in the first place. There are minor matters that, or there's things that just because of mitigating circumstances just shouldn't be pursued. A police officer doesn't stop every car speeding down the highway, depending on the circumstances, doesn't arrest every jaywalker, depending on the circumstances. Prosecutors don't have to proceed with the charges that are brought, and some prosecutors exercise very good judgment in choosing what to proceed with and what not, others less so.
It's been my experience if you are in a case, and it's typically a murder case because you have different grades of wrongful killing or wrongful death, first-degree murder down to involuntary manslaughter. It's been my experience that juries will often compromise among the charges, not because they don't think a particular charge was proven, but because they have some question about the case in general. And I most typically see that between first-degree murder and second-degree murder. If you can put any question into the mind of the jury about what really happened or about what or who really did the actual killing, if there's more than one person involved, the jury will typically go with the lesser verdict, I think perhaps to protect their conscience a little bit or to avoid feeling guilty. Have you had that happen?
Well, I think that's the inherent uncertainty of any jury trial. Neither the prosecutor nor the defense team knows for sure where the jury's going to come down in a particular case. So if both sides can marshal the strengths of their case, acknowledge the weaknesses of their case, they can almost reach a middle ground, perhaps a lesser charge in the example you gave, because there's evidence to support the claim that the mental state wasn't as high as first-degree murder requires.
And it does happen, I agree, and it's troubling when it happens because the standard of proof to obtain a conviction by a jury is proof beyond a reasonable doubt. If there's not proof beyond a reasonable doubt in a murder case, the verdict shouldn't be lessened from first degree to second degree. It should be an acquittal. If the person actually may be innocent, he shouldn't have to serve a lesser murder sentence. He shouldn't have to serve a sentence at all. So there is that kind of compromising in jury verdicts. I've seen it. It's happened in my own cases. It's probably happened in any experienced trial lawyer's cases. It's a little troubling, and that's another reason why the plea negotiating process is a legitimate one, because if a plea agreement can be reached that everybody agrees to and everybody is, if not satisfied with, at least not totally dissatisfied, but ideally everybody is satisfied with, it's the right result. The jury doesn't know what's going on in everybody's mind. The jury can guess as to who's being honest and who's not among witnesses who are presenting competing versions of the truth, or just who perceive things differently. But for the jury, it's really guesswork. They're not human lie detectors, and unfortunately some witnesses are dishonest, some witnesses exaggerate, some witnesses are just inadvertently just wrong. And to have a jury sort that out is sometimes the best we can do, but in many instances, if the parties agree to what the correct resolution of the case is, it's actually better. I hesitate to be here speaking in glowing terms about plea agreements, but often they are the right resolution and the best resolution. And I agree with Brian. Handing it to a jury is risky.
And Dan, I think what the public has to understand is, even if you use the term plea bargaining, it's not behind the scenes, off the record, behind closed doors. At least at the federal level, all plea agreements are in writing, so the defendant knows exactly what the terms are. Both state and federal courts require that the judge go over the agreement in open court with the defendant to make sure that he or she knows what the agreement is, that they understand it, and that they accept it. And you can't have a waiver of your constitutional rights unless it's a knowing, intelligent, and voluntary waiver. And what the judges do is, once that negotiation takes place off the record, there is a guilty plea hearing. In federal court, it's called a Rule 11 proceeding. Everything's done in open court to make sure that on the record those rights are given up in a knowing manner.
We're talking about plea negotiations. My guests are Attorney George Castell, Kanawha County Chief Public Defender, and Attorney Brian Kornbrath, Chief Federal Public Defender for the Northern District of West Virginia. I'm Dan Ringer, and this is The Law Works. When a defendant agrees to enter a plea, there are a variety of kinds of pleas that the defendant can enter. One is to say, you caught me, it's fair, I'm guilty, I did it, whatever it is. Right. Another is a no contest plea. I'm not admitting that I'm guilty, but I choose not to oppose a conviction because I kind of recognize I'm going to be convicted. And then the last plea is what is called in the federal system an Alfred plea. Yes. And sometimes in the state system in West Virginia, it's called a Kennedy plea because that was the case where Alfred pleas
Alfred
were recognized.
was adopted, yes.
Yes. What's the difference between an Alfred plea and some of these other pleas?
Well, in an Alfred plea, the defendant can continue to deny that he actually committed the crime, but acknowledge that the state has this body of evidence and he's choosing not to contest it rather than to face the greater consequences had he gone to trial. So it's a tough situation for a defense lawyer to be in, because if a person didn't commit the crime or insists he didn't commit the crime, the defense lawyer's job is to do everything possible to have him not be convicted of it in the first place. So I feel uncomfortable in a situation where the client is in effect saying, I didn't do it, but I don't have enough confidence in the legal system that I would get the correct result in court. So it's almost like admitting an inadequacy. So some judges have reservations about accepting offered pleas, and all of us are a little uncomfortable about the process, but to disallow it would be even worse.
Well, one of the horrible truths about the American system of justice is that if you don't have enough money to fund your defense in a criminal case, you may not get the result that you should get, that justice would define for you. And I have seen defendants stand up and say, Judge, I can't afford to pursue a defense in this case. I know I'm going to get convicted. I'm getting a lesser sentence by entering this plea, something I'm willing to accept than I might get at trial because of the evidence against me. So I didn't do it, but I'm entering a plea anyway. But that requires not only the consent of the defendant and the judge, but the prosecutor has to agree that those are acceptable reasons for entering the plea. But it just doesn't seem fair.
No, I think both sides have to be on equal footing. You have to be able to defend the case, have the resources to do so, uncover any defenses if they are there, and explain to the client if they're not there, here are your options in regards to plea negotiations or bargaining. It has to be equal footing. You certainly don't want the case where the defendant hasn't been able to make pretrial release and he or she are spending weeks, if not months, in a regional jail waiting for their trial date. A lot of people will say, I just want out. If I'm offered time served, I'll take the deal rather than wait for my jury trial, which is far down the line, and that's regrettable as well. Sure.
Or even in a case where they have to serve some additional time. I'm willing, it's hard to sit in your den or your living room or at the kitchen table and listen to a conversation like this and accept the idea that someone says, you know, serving another 5 years isn't so bad because I just can't stand this anymore, but I can stand that.
But the worst circumstance is the one you described where a person has a valid defense but can't or feels he or she can't afford to assert it. And that's that unfortunate middle category, those who qualify for a court-appointed lawyer, qualify for representation by the federal public defender's office or a state public defender office. If they have a defense that should be asserted, it should be asserted. And in my office, and I think in Brian's office, it is. Or there's always the maximum effort that it would be. The very wealthy, of course, if they have unlimited funds, can afford the highest quality defense too. But there's that middle category, and it's a large category of people who don't meet the eligibility guidelines, who are poor but not poor enough to be appointed to a public defender office, and yet can't afford the rates of the private bar. And they fall into that category where they could have valid defenses, can't afford to assert them, and that's really troubling.
When the defendant is in a situation of wanting to exonerate himself, but he's taking food out of the mouths of his family, clothing off their backs, because she has worked hard during their lives, they have accumulated some assets, and now they see that those assets are going to be, in a very real sense, wasted because they can't, to exonerate themselves, they have to spend every penny they've got. Where does the Supreme Court fall in all of this? Do they encourage plea negotiations?
Well, just last year they came out with two rather important cases that deal strictly with plea bargaining, and the Supreme Court acknowledges that it's a real situation. It takes place on a regular basis, and they finally have provided specific guidelines that must be followed within the plea negotiation context. Most importantly, that the defendant is fully advised of each and every plea agreement offered through the prosecutor's office in order to make a rational decision as to whether to accept or reject it. For example, in one case, there was a college student. He was a serial driver without a license. He was looking at 90 days to end the case if he took the plea bargain. The lawyer never shared that information with him. He went to trial, he was convicted, and received 3 years. And the claim was, had I known that that 90-day offer was on the table, I clearly would have taken it. And they actually overturned the conviction because the lawyer never shared that important information.
George Castell, Brian Kornbrath, thank you, gentlemen, for being with us. I want to end with this thought. Some people think that if they are using the services of a public defender or a court-appointed attorney, that they're getting the cheap lawyer. The finest criminal defense lawyers I know work for the public defender's offices or work with them as court-appointed attorneys. On behalf of the Law Works, I'm Dan Ringer. Thank you for being with us. Good night.
If you would like to suggest a topic for a future The Law Works show, or if you're a school teacher and would like to receive a DVD of this show for classroom use, send us an email to thelawworks@comcast.net or visit us on Facebook. On the Law Works website at thelawworks.org, you'll find a listing of recent The Law Works programs, additional information about this show's topic, and video of this and recent shows. You can also find the Law Works programs on YouTube and iTunes. The Law Works is produced in cooperation with the Office of the West Virginia Attorney General, the West Virginia Bar Foundation, the Mountain State Bar, the Monongalia County Bar Association, and the West Virginia University College of Law.
The Law Works is made possible by major grants from the Office of West Virginia Attorney General Darrell McGraw and from Software Systems Incorporated, a West Virginia company established in 1975 which provides high-end support services, programming, and consulting for county government AS400 mid-range computer systems as well as PC-based systems, and by a grant from the West Virginia Bar Foundation. The West Virginia Bar Foundation, the philanthropic organization for West Virginia's legal profession and justice system, promoting public knowledge of the law in West Virginia. Additional support for the Law Works is provided by the West Virginia Supreme Court of Appeals.
From West Virginia Public Broadcasting.